You're two streets from home when the torch swings across your windscreen. You pull over, wind the window down, hand your license across the way you'd pass the salt at dinner. The breath test comes back clear. You're already reaching for the gear stick when the officer leans in, friendly as a neighbour, and asks, "Mind if I have a quick look through the car?" On the passenger seat sits a straw still in its wrapper, a servo receipt, your daughter's school hat. Nothing to hide. But since the 1st of December 2005, when New South Wales switched on the Law Enforcement Powers and Responsibilities Act, that friendly question has carried more weight than most Australians ever learn. Because what you say next, in the next 10 seconds, with the wipers still ticking, can decide whether tonight costs you nothing, or your license, your record, and years of your life. The torch settles on your hands, so you keep them on the wheel. Get this part right because none of it is optional. When police signal you to stop, you stop. In New South Wales, that power sits in section 36A of the Act, and refusing turns a quiet night into a charge. You hand over your license when asked. You give your name and address. You blow into the tube because random breath testing doesn't need suspicion at all. It's the one genuinely random thing on this road. And if officers are lawfully exercising a power, Section 230 lets them use reasonable force to do it, which means resisting never wins. Not here, not anywhere in the country. So you do all of it, politely, while the radio on the officer's shoulder murmurs numbers and the wipers keep their slow beat. These are the concessions, and you make them in full. When the Act went through Parliament, the Attorney General of the day, Bob Debus, told the chamber it struck a proper balance between the need for effective law enforcement and the protection of individual rights. Balance. Hold that word while the torch drifts from your hands to the back seat, because everything you just did, you had to do. The look through your car, though, the friendly question still hanging in your window, that runs on entirely different rules. Here's the correction that changes everything. Because you've almost certainly absorbed the wrong country's law. American videos taught you the magic word, warrant. Cops need a warrant. Make them get a warrant. In Australia, forget it. Under Section 36, a police officer can stop, detain, and search your car with no warrant and no consent, right now on the gravel, if they suspect on reasonable grounds that it holds stolen goods, a dangerous article, anything used in what the Act calls a relevant offence, or a prohibited drug under the Drug Misuse and Trafficking Act of 1985. 5 listed grounds, and any single one unlocks the door. Yes, your car counts as premises under Section 3, and yes, a warrant over a vehicle exists. Section 47, for what Section 46A calls a searchable offence. But warrant applications are slow paperwork, and the roadside power is instant, which is why the overwhelming share of vehicle searches in this country happen without one. The warrant isn't the rule here, it's the exception. Queensland runs the same way under sections 31 and 32 of its Police Powers and Responsibilities Act. Victoria under section 82 of its drugs legislation and its weapons laws. So the question isn't whether they need a warrant tonight, they don't. The only question, the one this whole encounter balances on, is whether the officer leaning into your window holds 2 small words, reasonable suspicion. The torch crawls along your back seat while you sit still. And somewhere in the officer's head, a test is running that took courts decades to define. On the 24th of December 2001, in a case called R.V. Rondo, The New South Wales Court of Criminal Appeal gave the definition every lawyer in the country now recites. A reasonable suspicion involves less than a reasonable belief, but more than a possibility. It can't be arbitrary. It needs a factual basis, something real with actual weight, sitting in the officer's mind at the moment they act, not discovered afterwards. And here's what should steady your breathing. Rondo himself was a young man driving a car he didn't own who reached toward the glove box when police pulled him up. That was the entire basis. The court said no, not enough, not close. The stop and search were unlawful, the conviction was quashed, an acquittal entered. A borrowed car and a nervous hand didn't clear the bar. So while the torch pauses on your daughter's hat, understand what's really being weighed in this silence. Not what you look like, not the hour, not the suburb. Facts. And the list of things courts have ruled are not facts enough. That list is longer and stranger than almost anyone driving tonight would guess. Where are you heading tonight? The officer asks. Easy as small talk. And every question like it is a fishing line, because the pile of rejected grounds is tall. Back on the 16th of March 1998, in Street versus Bauer and Street versus Blanco, the Supreme Court looked at vague police intel calling a car a suspect vehicle, plus the late hour, plus 3 men inside, and said that's not suspicion. That's a hunch wearing a uniform. The same case settled something you should carve somewhere permanent. Robustly refusing to consent to a search is not grounds to search you. Saying no is not evidence. A criminal record on its own? Not enough either. A New South Wales District Court said exactly that in 2010. And the breath test itself can't be used as a disguise. In RV Buddy in 2016 and RV Large in 2019, District Court judges condemned searches that began as random breath tests and morphed into drug hunts because RBT powers exist for alcohol, not as a ruse for crime detection. Blow negative, and the negative doesn't quietly convert into grounds to open your boot. Each of those cases was a real person on real gravel watching their real back seat get opened, and a court later saying it should never have happened. So the torch alone can't lawfully unlock your car. But some things genuinely can, and one of them may already be walking up the white line behind you. What clears the bar? Courts have accepted a cluster, and the pattern matters more than any single item. A drug detection dog sitting down beside your door. The Act allows general drug detection without a warrant, and a positive indication routinely counts towards suspicion. The smell of cannabis rolling out of your window? Australian courts treat smell as a contributing factor inside the whole picture rather than a magic key. But stacked with anything else, it stacks fast. Furtive movements paired with specifics. And the biggest one, the one drivers hand over for free, admissions. The moment you answer, anything in the car I should know about, with anything but calm silence or a polite no, you're not chatting. You're building their grounds in real time, out of your own mouth, onto a body-worn camera. Now the hard line, and hear it plainly, there are no magic words, no sovereign citizen script, no I'm travelling, not driving, no printed pseudo-legal card changes one clause of the Act. And physically obstructing police is its own offence in every state, with Queensland's section 791 waiting for exactly that mistake. The law at your window tonight is the real law, and it only bends where it's written to bend. Which brings us to the strangest lever in this whole encounter. Because there is one thing that can make an unlawful search perfectly lawful, And it isn't a dog, a smell, or a fact an officer can find. It's you, consent. On the 28th of April 2000, on the Sturt Highway, a man named Troy Leonard was stopped for a breath test, and police searched his car partly because it was a hire car on a well-known drug route. The Supreme Court later held that was not reasonable suspicion. A rented sedan on a highway thousands of innocent people drive proves nothing. But here's the part that matters in your window right now. The court also examined whether Leonard's consent saved the search, and it failed only because he was never told he could refuse. Read that in reverse and you can see the machinery. Informed consent. A driver who knows they can say no and says yes anyway makes an otherwise unlawful search lawful. Every ground the officer lacks, your yeah, go ahead supplies. That's why the question arrives so soft, so neighbourly, while the wipers tick. It sounds like courtesy, and it functions as a signature. One Sydney criminal firm states the reality flatly. Most vehicle searches are not conducted with warrants, and a healthy share of those run on nothing more than a driver's shrug. You're allowed to decline, and declining, remember street, cannot itself become their suspicion. The exact words are coming. The calm, complete sentence that protects you without handing over anything. But before they land, you need to see how far this power spreads beyond your driver's seat and what it becomes across a border. Cross a state line and the skeleton stays while the details shift. In Queensland, Section 60 of the Police Powers and Responsibilities Act lets officers stop you for prescribed purposes, a breath test, a licence check. But Section 60 is not a search power. To open your car, they need consent, a warrant, or a Section 31 reasonable suspicion of a Section 32 circumstance, unlawful drugs, weapons, stolen or tainted property. And Queensland courts police that line. In R.V. Davis in 2023, officers on patrol hunting drug offending stopped a car, ostensibly a licence check, then claimed suspicion after spotting cash. The Supreme Court excluded the drugs, and under R.V. Keane, it's the Crown that must prove the factual basis for the suspicion actually existed. Victoria hands police Section 82 of its drugs legislation for suspected drugs of dependence, Section 10 of the Control of Weapons Act for weapons, then goes somewhere nothing else tonight goes. Declared designated areas where police can search a person, their things, or their vehicle for weapons with no individual suspicion at all. Presence is enough. Stand in the wrong postcode on the wrong night, and the reasonable suspicion gate you've been learning simply isn't on the door. Different states, one constant. The warrant is nobody's rule, and none of this stops at the driver. It reaches every seat in the car, and at its worst, under clothing. Your passenger's bag on the floor sits within the vehicle power. Your passenger themselves can only be searched on their own reasonable suspicion under Section 21. And above it all hangs the escalation the law fears most. A strip search in the field is lawful only when officers reasonably suspect it's necessary and the seriousness and urgency of the circumstances demand it. Sections 31 to 33, privacy rules attached, an outright ban for children under 10. Now hold what happened to Raya Meredith. On the 20th of July 2018, at the Splendour in the Grass Festival, a drug dog sniffed in her direction. She was strip searched. Nothing was found. On the 30th of September 2025, Justice Dina Yahia ruled that search unlawful. A dog's indication does not make a strip search seriously and urgently necessary. Finding a flagrant disregard for the rights of the plaintiff and police training that was wholly inadequate. Damages $93,000. Behind her stand more than 3,000 registered group members in the largest class action ever brought against an Australian police force. UNSW researchers had already documented an almost 20-fold increase in less than 12 years in field strip searches, and in 2018 to 2019, suspicion of drug possession accounted for 91% of the recorded reasons. That is the machine idling behind the friendly voice at your window. So, the exact words, "You've waited long enough." They open the next chapter, and once you have them, they're yours for life. First, one number to hold while you speak. Across 2 recent years, New South Wales Police ran 4,477 field strip searches, and in nearly 60% of them, nothing illegal was found. Majorities of empty hands, and when the practice was challenged publicly, the police commissioner of the day, Mick Fuller, told a newspaper in November 2019 that people need to have respect and a little bit of fear for law enforcement. Fear on the record. That's the climate your 10 seconds live in, and it's exactly why your words matter. Here's the payoff. In 3 moving parts, then whole. Part 1, no consent. Because consent is the signature that legalises everything. And Leonard taught you it's yours to withhold. Part 2, no obstruction. Because resistance is a separate crime and force is their lawful tool, never yours. Part 3, the status question. Because it forces the encounter to declare itself, detained under a power or finished. Say it with me, slowly. Officer, I don't consent to a search. I'm not going to obstruct you. Am I free to go? Once more, because the second time is the one that sticks. Officer, I don't consent to a search. I'm not going to obstruct you. Am I free to go? Screenshot this. Say it out loud once tonight, so it's yours before you ever need it. Now watch what each clause is doing, because there's no wasted word. Clause 1 hands over everything the law actually owns. The license, the directions, the musts offered before he asks, which kills the word uncooperative before it can be written. Clause 2 closes tricks 1 and 2 in 9 syllables. No admissions, no timeline, no reconstructed Friday night. And Section 89 makes every bit of that silence free. Clause 3 closes trick 3 forever. And after Leonard, you know exactly what it's really doing. It's withholding the warrant. The only warrant he could ever get from you. Delivery is half the sentence. Calm, polite, flat. No speech about rights, no lecture, no edge in the voice. The words carry the law. Your tone just has to carry the words. Say it once, and if he asks again, say it again, identically, like a recording. Against 4.5 million stops a year. Boring is invisibility, and invisibility is the win. Must satisfied, questions closed, consent withheld, the stop has nowhere left to go but forward, to the ticket or the good night. And now he pushes. They always push. Push 1 comes wrapped in convenience. It'll be a lot easier if you just let me have a look. Easier for whom is never specified. You don't debate it. You repeat unchanged. Officer, I don't consent to a search. I'm not going to obstruct you. Am I free to go? Push 2 comes wrapped in innocence. If you've got nothing to hide, this will take 5 minutes. The wipers tick. The straw sits in its wrapper. Same words, same tone. Officer, I don't consent to a search. I'm not going to obstruct you. Am I free to go? Now the fork. and it only has two times. Either the officer decides the grounds aren't there and you're driving home, or they assert reasonable suspicion and search anyway, which the Act lets them do over your objection. If it's the second, you step out when directed, stand where you're told, and let it happen, because the argument now belongs to a courtroom, not this roadside. Under Section 202, they must give you their name, their place of duty, and the reason ask. Because once you've asked, a refusal to answer starts to matter legally. Your phone is different terrain, and you can film calmly, one hand, no commentary needed. Ask that their body-worn cameras are recording, because yours and theirs together become the record this night lives or dies on. When they leave, before you drive off, write down everything: names, numbers, times, words used, then sign it and date it, because memory fades and signed notes don't. Your phone is different terrain. Police can seize it during a lawful search, but out here, nobody can compel your passcode or your face. That takes a digital evidence access order, a regime that only commenced on the 1st of February 2023. And defying an actual order risks $11,000 and 5 years. Tonight, there is no order. And if they search and they find something and the search was unlawful, you'd assume it's over, thrown out, done. This is where Australia breaks your heart. There is no exclusionary rule here. On the 14th of June 1978, in Bunning versus Cross, the High Court held that unlawfully obtained evidence is not automatically inadmissible. Courts weigh the public interest in convicting wrongdoers against the public interest in protecting people from unlawful treatment. In that very case, the illegally obtained breath evidence was admitted because the breach was a genuine mistake and the offence serious. Today, the balancing lies in Section 138 of the Evidence Act. Improperly obtained evidence stays out unless the desirability of admitting it outweighs the undesirability. Probative value, gravity of the offence, deliberateness of the breach, all on the scales, with the prosecution carrying the onus. Sometimes the driver wins. Buddy's drugs were excluded, Davis's drugs were excluded. Often the drugs come in anyway, and the conviction stands on top of the unlawful search. That is the single most un-American fact in this entire video. So where's the real leverage? Civil. An unlawful search is a trespass to the person. A wrongful detention is false imprisonment. Neither needs malice. Figures obtained by a Greens parliamentarian and reported in October 2020 showed New South Wales paid out $89.6 million across 968 civil cases in 4 years, averaging just over $92,000 a settlement. And the force fields roughly 300 claims a year. Complaints can also go to the Law Enforcement Conduct Commission. This is the lane the Meredith lawyers drove down. The searches, one of them said, had run on an industrial level at festivals with little regard for the safeguards. The money, the accountability, the appeal running right now, all of it flows back to the same 10 seconds at your window. And yours are still ticking. So, one breath. Stop, license, name, breathe. Those you owe in full. Then the words, unchanged. Officer, I don't consent to a search. I'm not going to obstruct you. Am I free to go? Their side needs less than a reasonable belief, but more than a possibility. Rondo's line, standing since 2001. And this is education, not legal advice. If tonight goes wrong, your next call is a lawyer, not a comment section. The torch clicks off. The window rises. You roll the last 2 streets with the radio low and the porch light waiting. And tomorrow we stand at a different threshold because the next question is, can police enter your home without a warrant in Australia? And that answer will surprise you too. For now, the driveway, the engine ticking cool, the straw still in its wrapper, and your daughter's hat riding home on the seat beside you.